Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be discussing basics of the right to know law. Let's get a couple preliminaries out of the way before we jump into the session itself. First, the format of these sessions, if this is your first time attending, is that there's a PowerPoint with me speaking, narrating as we go through. The PowerPoint, as well as all of the PowerPoints that we use for these webinars, are available on our website under the Training tab. Feel free to access them and download them as you see fit, whether it be for your own personal reference or if you're conducting any sort of local training. Also, this session is being recorded, and the recordings are available through two means. The most common is contact our office, ask for to be linked up to the recording, and there's a file sharing service where they'll send you a link and you'll be able to access it that way. If by some chance, maybe your computer security system doesn't allow that access, or you just don't have the ability to do that, what you can do is mail a flash drive to our office along with a note and a self-addressed stamped return envelope, and they'll be happy to make a copy of the recording and mail that back to you. Just be sure to include, which recording you're looking for. Usually the date works along with the subject, and then include that self-addressed stamped envelope so that we can get it back to you at the appropriate address. If you have any questions today, feel free to type them in the meeting chat feature as we're going through. Two things I would ask: that first offhand, you keep your questions on point. We're talking about Pennsylvania's right to know law, so your questions should, refer to whatever we're talking about. Second, please try to keep your questions as brief as possible. Occasionally, folks will type in several paragraphs, and honestly, it's just awkward for me to sit here and, that silence, that awkward silence for me to read through it. If it looks like, you've encountered a situation that's unique to your particular agency, or, your question is unusually complex, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it. We'll deal with it there for the benefit of everybody. Or it might be best just to take the conversation offline. Contact our office. There's administrative staff who can help you out, or they can refer you to one of our attorneys here at the office who can hopefully get you steered in the right direction. But yeah, try to keep your questions on point and, if possible, as brief as you can. Okay, so all that being said and behind us, let's go ahead and start talking about the right to know law. There's a lot of misunderstanding about the right to know law, so let's just jump right into it by, talking about, first offhand, why is it important? Well, it gives the citizenry access, it promotes transparency with government, and it just is a good government practice, no secrets, where we try to put all of the records out there for the public's viewing. Which brings us to the purpose of the right to know law. And I think that it's important that we get this foundational statement out there because of all that misunderstanding as to what the right to know law actually entails. So the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems like a no-brainer, but like I said, there's a lot of misunderstanding. I think on both sides of the equation, where some folks view the right to know law as, government's version of Google, where they can basically write out any question, send it in, and government has to run around and find out the answer. Well, that's not the case. And I find that, if you encounter a right to know request that has you a little confused, or you're just not sure what direction to take, sometimes it's good to come back to this foundational statement. It's to give the public access to public records, no more, no less. And a lot of times that can get you steered in the right direction, and you can begin the search for what the person is actually asking for. Now, as far as the law goes, there's a couple also, fundamental precepts here that we have to be aware of. First is that every record of an agency is presumed to be public. That is your starting point. And you work back from there. Next is that agencies, meaning, whether it be a city, borough, township, authority, school district, any other government entity in Pennsylvania at the state or local level, they bear the legal and factual burden of proving that a record is not public. So your beginning point is that you presume all records of the agency are public unless the agency can meet its legal burden proving that it is not. Now, from an agency perspective, that seems rather daunting. Quite often, someone gets appointed new as the agency open records officer, or they get their first right to know request. They hear this and they get all wigged out and think, oh my gosh, everything in the office is going to end up on the front page of tomorrow's paper, or somebody's going to put it on their Facebook page. And I'm here to tell you that that's not the case. There are quite a few tools that if you are, if you're working for an agency and you receive a right to know request and it just doesn't feel right, it's like, I really don't think this should be out there in the public domain. There is a very good chance that there are tools within the right to know law or other laws that will support that anxiety that you have and probably provide you with that legal burden for withholding the record. But I think, we need to take a look at what those tools are to ensure that that red flag that went up, in fact, is legitimate. But keep in mind these two fundamental statements. The record is presumed to be public unless the agency can prove otherwise. And remember, the purpose of the right to know law is to give the public access to public records. Okay, that being said, let's move on. And I want to emphasize the fact that the right to know law is not a confidentiality law. Okay, what am I talking about there? Well, first offhand, there's nothing in the right to know law that prevents you from simply giving out public records. Let's say it's budget season and there's a draft budget getting ready to be approved by a board, or maybe the board has already approved it. And members of the public want to see what that budget looks like, and you happen to have a stack of budgets in the office. Let's say I'm a member of the public. I come walking into your office and say, I'd like a copy of the budget, please. There's nothing in the right to know law that prevents you from simply handing me a copy of that budget. I do not need a right to know request in order to get a copy of that budget unless you say so. Okay, the right to know law does give you that discretion, that flexibility, that if you want to require a right to know law, a right to know request, you can do so. But, that's going to involve more time and work for everybody involved. So you can simply give me a copy of that budget or any other obviously public record without requiring me to file a right to know request. Further, nothing mandates that you have to use the right to know form. And we're going to talk about that here in a little while. I can simply send you a letter or a note or something like that. Whether or not you require an actual form, again, it's at your discretion. And, I can have a form completed that's asking for a copy of the budget. And you can say, you know what, George, it would save me a lot of paperwork and you a lot of time if you would just tear up that form and I'll give you a copy of the budget. Okay, you can do that because, why wouldn't I agree to that? I'm getting what I'm asking for, and you're saving yourselves probably a lot of paperwork. So, the moral of this is you don't need a right to know request in order to give out an obviously public record. And what we recommend is that, if you have a website, you should be posting all of the more commonly sought out records. Take a look at your previous right to know requests and what are people asking for? Usually budgets, contracts, salary information, purchasing documents. If there's some, high visibility project that the agency is involved with right now, maybe it's, some land development or some zoning issues. Maybe it's purchasing some new equipment for the township or whatever. People are going to be asking for records related to that. So put them on your website, kind of like as a preemptive strike. And what the right to know law allows you to do then, next time you receive a request for those records, your response can be, that's on our website, here's the link, problem solved. And our experience has been when you do this, when you use your website as a business platform for posting commonly requested records, um, first offhand, the hits on your website start going up. Secondly, the right to know requests start to drop off. And that's a good thing. That's saving you work. And quite honestly, it's what the public expects nowadays. They would much rather sit in the comfort of their family room on their home computer, surfing your website for the records and the information that they're looking for, than the alternative, which might involve taking an afternoon off from work, coming down to, Borough Hall or the township building or the school district administrative offices, submitting a right to know request and potentially waiting over a month to get the records that they need. Okay, so put them on your website, use your website as a business platform, and it will help everybody out, including yourselves. Okay, so we're assuming that you're here because your agency is subject to the right to know law, or you're a member of the public curious about finding out what this law actually entails. So from an agency perspective, there are some things that you must do. Most importantly is appoint an agency open records officer, or this person may also be referred to as the right to know officer. It's the same thing. The two phrases, two titles are interchangeable. We call them arrows. Okay, and this is the person responsible for receiving, processing, and responding to right to know requests. So there is a degree of legal obligation here. Um, the arrow can be anyone, any employee or elected official within the organization. For instance, a school district, it could be the person you encounter at the front desk when you walk into the administrative offices, or it could be the district superintendent. The right to know law gives you the discretion to appoint anyone really as a matter of handling these responsibilities. Also, you can have more than one arrow. It's not unusual to go to one borough and they have one person covers the entire organization soup to nuts. I can go 3 miles down the road to the next borough and they may have one person covering the administrative side and then a second person covering law enforcement, the police department. That's fine as long as it's clear to the public. Who do I give this right to know request to? Who do I need to contact? Who do I need to interact with in order to get the records that I'm looking for? This person doesn't need to be voted on by the board. They don't need to be sworn in any way. We simply regard it as a job duty. Agencies also have the discretion to promulgate their own local regulations, policies, and practices to help administer your own open records program, as long as it doesn't conflict with the right to know law, or as long as it doesn't conflict with any rules promulgated by the Office of Open Records. I'll give you a quick example. The right to know law says that an agency may accept anonymous requests. Well, there's another law in Pennsylvania known as the Statutory Construction Act that kind of helps us interpret phrases. And because the right to know law uses that word may, it also means may not. So an agency could adopt a policy that says we will only accept right to know requests where the person is identifying themselves. We will not accept anonymous requests, okay? And there are other examples where, again, the right to know law gives you the discretion to administer your open records program as best fits your organization. Now, you can also have your own form, your own right to know form. And a lot of agencies do that. They like to have their seal at the top, perhaps the contact information for their arrow, any of those local rules, cost information, et cetera, et cetera. but you must also accept the uniform request form, which is, the state form from our office. It's on our website, readily available. Some agencies simply link to that, and that's fine, but you must accept that if someone submits it. Also, we ask that you provide our office with the name and contact information for your arrows. Again, on our website, we have a database of all the arrows statewide. Some of them are self-populating. We have a link to the Department of Community and Economic Development's Mundstat site, but we also recognize that, people move on. They get promoted, they retire, move to another agency. So it's important that we be able to keep this information up to date. So periodically, you want to check our database, make sure that your arrow information is accurate. And if not, there's a form there that you can fill out, email it to us, we verify it, and then we update the database to ensure that it's correct when people contact us or they access the database directly. And if an appeal is filed against your agency, we usually refer to the database to reach out to the arrow to let them know that they have an active appeal and there's important things that they need to do. Postings. Yeah, you have to have postings physically within your offices, or if you have a website, then it needs to be part of your website, your web pages. And it needs to include, again, the contact information for the arrow. Look at this from the public's perspective. They don't know anything about this law or how your borough, how your school district operates. So you need to educate them and use your postings and your websites to do that. Contact information for the arrow. Who do I give this to? Contact information for the applicable appeals office. And in the greater majority of cases, it's going to be the Office of Open Records. And I think the best thing you can do there is just put the URL for our website, because most of our interaction with the public we do through our website, and that interfaces with our docketing system, et cetera, et cetera, et cetera. So it works out rather well. Then you need to have a form available so that if that citizen doesn't have a form, you have one that you can give them if you're going to require them to fill one out. And then finally, list any of those regulations, policies, and procedures that your agency may have adopted locally in order to administer your right to know program. Okay, so fairly easy stuff. But keep in mind, don't just put the bare necessities. You want to use this as an opportunity to educate the requester. My experience is the better educated the requester is, the smoother it's going to be for everyone as you work your way through this process, because surprises are bad. If you end up surprising a requester through some, rule or policy or maybe costing information that they're not ready for, they're going to get frustrated, and then things are going to go south from there. So do your best up front to make sure that the requester knows what the playing field looks like before they actually enter the game. Okay, what can't you do related to the right to know law? Well, these are detailed in Section 1308 if you want to look at the law itself. Again, on our website, you can download the law. It's not a hard law to read. It's not that long of a law. For the most part, it's written in common English, and you can pretty much understand, what is being said here. But essentially, two things. First offhand, you cannot limit the number of records or requests that a person is filing for in any specific period of time. You can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. If she's inclined to file a dozen requests this week, or, ask for a dozen records, the right to know law allows her to do that. The second thing that you cannot do is compel a person to tell you why they are filing a right to know request. You cannot deny a request based on the reason or what you think that reason may be. Okay, now let me go off script just for a second here. The greater majority of requests are received from people who are legitimately looking for public records. But there are a handful of people out there who have weaponized the right to know law. For whatever reason, the relationship between those citizens and the agency has broken down. They've decided they're going to be a pain in the neck, and one of the ways they're a pain in the neck is to file a lot of right to know requests that usually are not for legitimate records that they need. There are a number of initiatives within the legislature to deal with that. Usually the term associated with it is vexatious requester. But also what I recommend is learning about the payment side of the right to know law. I'm going to talk about that briefly today, but we also do a separate webinar just on payment issues. And you want to learn about that as a means for hopefully dealing with these disruptive requesters. Okay, but back on script now. You cannot deny a request based on the reason or what you think the reason is, even if that reason might be that person just wants to see you work harder. Okay. Now, let me get a sip of coffee here quick. Okay. For the next several slides, I'm going to use the metaphor of the right to know law as an obstacle course. I think this is a visual, mental visual that I think helps us work our way through the process of how you handle a right to know request. So you've got the start, which is where you receive the request. And then there's kind of like time standards. I don't know if you're familiar with high-level competition at all, but not anyone can go to the Olympics. You need to be able to pass a time standard. So you've got deadlines built into the right to know law. And these deadlines are hard. There's no wiggle room. The law says 5 business days. The law says 30 calendar days. And it doesn't say, maybe if you can get them done. It says you must get them done. Then you've got the first hurdle where we need to answer the question, is the request seeking records? Then we've got the second hurdle. And in front of that second hurdle, though, there are 3 hoops that we need to get through. And then once we get over the second hurdle, we're on our way to the finish line. Okay, so let me work our way through this obstacle course. Okay, we receive the request. The gun is fired and we're starting here. The first thing we need to do is note the date that the request is received. And that can be, a timestamp, just writing it on the form or whatever. But this is because the first deadline is that you have the agency has 5 business days to provide an initial response, and they are the agency business day. Okay, now first, let's say that the request is received today. Presumably then, tomorrow is your first business day. And because they're your business days, we recognize the fact that not all agencies are on a Monday through Friday schedule. Now, first off, and let me get it out of the way. If you're like law enforcement and you're open all the time, it would be whenever your administrative offices are open and the public has access. So a business day would not include a holiday. It would not include a weekend. It would not include a day closed for, a weather emergency. And let's say that you're a small township up in the northern tier of Pennsylvania and you're only open 2 days a week. Your business day, hypothetically, would be your 5 business days would be Monday, Tuesday, week 2, Monday, Tuesday, week 3, Monday. Then the close of business at that 5th business day would be when your initial response is due. You see how that works. If you're a school district, and let's say during the summertime, you're not on a Monday through Friday schedule. Maybe you're only open 3 days a week. That's how you would calculate the 5 business days. So let's then say that, well, before I jump into extensions, let's just talk about keeping copies, okay, because this can be a little confusing. The right to know law says that you maintain copies of all requests and associated materials for at least 30 calendar days or until all appeals have been exhausted. Now, hopefully you would know whether there are any appeals outstanding, but keep in mind that if it's wending its way through the courts and getting up to the Pennsylvania Supreme Court, this could be years. Okay, so, maintain that contact with your solicitor just to make sure you've got copies of everything you should have until all appeals have been exhausted. Then we have another law that you should be aware of, and this is the Pennsylvania Municipal Records Act. And if your agency happens to have adopted this as your records retention guide, then the Pennsylvania Municipal Records Act says that you should maintain all right to know materials for a minimum of 2 years. And again, if there are appeals out there that extend beyond 2 years, keep them for whatever is longer. Now, the Municipal Records Act applies to municipalities. There's nothing comparable for school districts, but if you want to voluntarily adhere to this, you can. Okay. Same way for authorities. I don't think the act applies to authorities, and I have not found anything in the Authorities Act that deals with records retention. But keep that in mind. I would recommend following the Municipal Records Act 2 years to keep everything related to records retention for right to know materials. Okay, extensions. Let's say you, for whatever reason, you cannot provide a response within the 5 business days. Right to know law allows you to take a 30 calendar day extension. Note the difference. Now, calendar days do include holidays. They do include Saturday, Sunday. They do include weather emergency closings. Okay, but in order for the extension to be valid, there are some conditions that need to be met. First is that you need to invoke, the agency needs to invoke the extension within the 5 business day window. You can't wait until what would otherwise be the 6th business day, say, oh, I forgot about this right to know request. Well, we'll just take the extension. Unfortunately, you've already deemed denied the request you're basically denying it by default once you miss that extension. Okay, question has popped up here. We are currently keeping a database of all right to know requests. How far back should that database go? 2 years voluntarily. We are a school district. Michelle, there's nothing in the right to know law that would actually refer to that. We're talking about, previously we were talking about all materials, the request and any related correspondence. If your database, which I applaud you for keeping that, if that's just keeping kind of like track of dates and so forth, summary of what the request was, there's nothing within the law that really speaks to that. So I think it's at your discretion. Because it's an electronic database, doesn't take up a lot of room. I really wouldn't see a need for clearing it out periodically. You could archive older files, but again, that's probably at your discretion with how you manage your open records program. But good idea for keeping that database, and I would recommend everybody take a look at something similar to that. Okay, back to extensions. So you need to take it within the 5-day window. You need to notify the requester that you're doing it in writing. And if the request came in by email, you can respond back to the requester by email because it is in writing. You need to provide a reason why you're taking the extension. And if you look at Section 902 of the law, it actually lists 6 reasons. One of them is we keep these records off-site. It's going to take us longer than 5 business days to go through them and see what is responsive. Another one could be we need our solicitor to review these records to make sure we're not giving out anything we're not supposed to. So you select the appropriate reason and put that on your response or your invocation of the extension. Then you need to provide a date as to when the requester can expect to get the response. Usually it's on the 30th day of the extension. Okay, and then an estimate of any costs that the requester can expect to incur. And it is just an estimate. It's not a hard quote. So it can be a little higher, a little lower. You settle up on the exact amount when it comes time to actually provide the records. So you've got the 5 business days, and then the 30 calendar days get tacked on to the end of those 5 business days as your response period. But I want to caution the agencies. Don't just automatically take the extension if you don't need to. Okay. If you can provide the response within the 5 business days for what are obviously public records, please do so. When someone submits a right to know request for something that is clearly a public record, and then the first contact they get back from the agency is, oh, we're taking a 30-day extension. Boy, that just doesn't sit well. And people complain about that. It sours the relationship with your agency, and it's just not good customer and public service. So, while I realize bench strength is limited, maybe you've only got one person doing this and they've got a lot of other duties. If there's any way you can avoid automatically invoking that 30 calendar day extension, please do so. Okay, so we're now up to that first hurdle. And let's see, question has popped up here. What does it mean to have received the request? If the arrow is out of the office for a day or on vacation, okay, that's a great question. And there's actually a court case that speaks to this. It's, okay, it was versus the governor's office. Donahue versus the governor's office. And Sean, what it basically says is that the clock starts ticking when the request is received by the agency open records officer. So technically, if the arrow is on vacation, the clock doesn't start ticking until the arrow returns. However, I want to encourage you to communicate with the requester. If that were to happen here, well, first offhand, we have alternates so that, if the arrow is out of the office, there are other people who can log in the request and the clock starts ticking immediately. But if that's not the case for your agency, have an out of office reply that lets the person know, hey, I'm on vacation or whatever, I'll be returning on this particular date, and that's when we'll begin processing your right to know request. Remember what I said, no surprises, communicate with the requester. The better you can do that, and an out of office request is one of the ways to do that, the better things are going to go, the smoother everything's going to go for you. Good question. You might want to refer to that court case, which you can, again, you can find a link to it on our website in the court case summary. Different term we use anyway. But yeah, the court digest, the case digest. You want to take a look at that. Okay, again, good question. Okay, so back to the slides here. We have to answer the question, is it a record? Notice I didn't say, is it a public record? But is it a record? Now, whenever you're trying to understand a law, you want to take a look at the definition section. And the right to know law is no exception to this. When the language in a law is somewhat vague or confusing, a lot of times you can find clarity by reading the definitions. And sure enough, the right to know law has a definition of what is a record. And I'm going to take it right out of the law here. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase in red here, documents a transaction or activity of an agency. English, the record has to be about what it is we do with our agency. Okay, and you're thinking, well, yeah, why wouldn't we have records like that? And that's because all day long we generate communication messages that don't necessarily rise to the definition of a record. Okay, I hear a new restaurant's opened up downtown. You want to meet for lunch tomorrow? Or Hey, did you see the game last night? What do you think of the trades the Eagles have made and how it looks for their season? Or I'm picking up a gallon of milk on the way home tonight. Okay. All fairly common messages, but yet have nothing to do with the mission of our agency. Thus, they do not meet the definition of a record, and they don't make it over the hurdle. Okay, they're off the course. So I don't need to worry about communications like that being given out in response to right to know requests because they have nothing to do with our agency. You see how that works? They are not records. Now, let me throw out another example here. Let's say that I am a township supervisor. I'm at home in my family room. I'm on my personal computer and I'm on my personal Gmail account. But I send a message to my colleagues on the board that, hey, I understand at tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have a couple issues with this proposal. Here they are. Honestly, at this point, I'm thinking about voting against it, but why don't you guys tell me what you think? Okay, and you send that off to the other supervisors. Now, yeah, I just violated the Sunshine Act, but we'll talk about that in 2 weeks. Okay, but for purposes of this example, the fact that I'm at home on my personal computer using a Gmail account doesn't matter. It's the subject of the record, the subject of the communication that determines whether or not it's a record. Okay, and I'm talking about township business. Okay, I'm exercising my authority as a supervisor. I'm, bringing up a matter that's before the board and will have an impact on the public that we serve. Clearly a record and would be discoverable under the right to know law, even though it's on a privately owned computer using a privately administered account. Okay, one of the very first legal decisions related to the right to know law was that you cannot use private devices and private accounts to hide the public's business. Now, you're not doing anything illegal by using your personal computer or using your smartphone to communicate back and forth. Okay, but just be put on notice that those communications could be discoverable under the right to know law because you're discussing public business. Okay, so we've made it over the first hurdle. Now we need to come up on the second hurdle and answer the question, is it a public record? Notice the distinction. First one, is it a record? Second one, is it a public record? But we've got a couple hoops that we have to get through before we can even jump over the hurdle. The first one, we have to answer the question, are there any exemptions that apply? And if so, are we going to invoke them? What the heck is an exemption? Well, if you're looking at the right to know law, you would go to section 708B, and listed there are 30 exemptions. An exemption is basically a description of a type of record that the agency has the discretion to withhold from public disclosure because of the sensitive nature of that record. And these exemptions are fairly broad and cover, a very broad scope of records. And like I said at the beginning, if you receive a right to know request and you're just not feeling comfortable about releasing these records, there's a very good chance it would be covered by one of these exemptions. For instance, there's an exemption that says if by releasing this record, it would put someone in physical danger, you could withhold it. There's another one that covers like academic transcripts. There's one that covers, any information that might release the home address of a minor. Okay, you would withhold that. Educational records, health-related records. Okay, all exemptions within the right to know law that when you look at them, it kind of makes sense. Well, yeah, we wouldn't give this out as a public record because of, the danger it could possibly create, or, just violating someone's constitutional right to privacy. We would not give out certain information of this nature. So chances are there would be that exemption. Now, when we talk about, meeting the legal burden, there's a very good chance you would refer to the type of record and say, this falls within one of these exemptions, and then you would cite that exemption as the basis for your legal burden for withholding the record. Okay. And remember that these exemptions are discretionary. They're voluntary, if you will. Even though a record may clearly fall within the exemption, the right to know law allows the agency to release the record if it believes it's in the public interest to do so. But then we come up on the second hurdle, which is kind of, in a way, it's both supportive of and in some ways contradictory of the exemptions. And here we have to answer the question, are there any federal or state statutes or a judge's order that make the records non-public? In the right to know law, you refer to Section 306. But basically, to paraphrase here, what it's saying is that if there are any other laws that say a record is confidential, then that law trumps the right to know law. It supersedes the right to know law. And usually these other laws remove the discretion that you would otherwise have with the right to know law. Remember, the right to know law is not a confidentiality law. It doesn't mandate any records to be confidential. However, it does defer to any other laws that do. So, for instance, if you're familiar with law enforcement, there's a law called CREA, the Criminal History Records Information Act. The right to know law may allow you to release records related to criminal intelligence information, but CREA does not. CREA says it's clearly confidential and can only be shared within the law enforcement community. Okay, so CREA would trump the right to know law. Health-related statutes. If you go to, the federal alphabet laws, you could be looking at HIPAA, you could be looking at ADA, you could be looking at FMLA, all laws which make health-related information confidential and would clearly remove any discretion that you would otherwise have with the right to know law. As a matter of fact, you would be violating federal statutes and perhaps opening yourself up to personal liability and criminal liability by releasing health-related information. School districts are familiar with a law called Ferpa, the Family Educational Rights and Privacy Act, which makes it illegal for them to release individual educational records for fear of losing their federal funding. Okay, so they cannot release educational records that would otherwise be accessible under the right to know law. So you're answering this question, is there another law? And by the way, we do a webinar on other laws that have confidentiality statutes in them that we most frequently encounter here at the Office of Open Records. You might want to sit in on that webinar if you're not familiar with this topic at all. Okay, so if there are no other statutes, then we make it through the second hoop, and now we encounter a third hoop where we've got to answer the question, is the record protected by privilege? Here we're talking about attorney-client privilege. Usually, there's a relationship established between an attorney and their client where any sensitive information is protected by privilege. And for our purposes here with the right to know law, we're talking about agencies and their solicitors, whether it be, in-house counsel or outside counsel. And any communication, whether it be email or memos, reports, even invoices that transpire between the solicitor and the board or senior management is usually protected by attorney-client privilege. But if it's not, we make it through that third hoop, and then, and only then, can we jump over the second hurdle, because we're saying it is a public record at this point. And when we do that, we're basically approving the right to know request and identifying records that are considered responsive and would be granted in response to that right to know request. Okay. But before we give out the records, we've got to come up with a way, a bill for the person to pay. Now, this is another fairly highly misunderstood area of the right to know law. The deadlines apply to the responses. Are we denying or are we granting the request within 5 business days or within the 30 calendar days? The deadlines do not refer to when we provide the actual records, okay? We provide the records once we have granted the request within the deadlines and usually within a reasonable period of time, okay? Subjective phrase, but it's kind of like what's reasonable and what's not. And you can have a payment, an invoicing system set up that once you receive payment, then you provide the records, okay? And that's all outside of the deadlines because you're not going to find much in the way of information within the right to know law related to when you provide the actual records. All the right to know law says is that records are provided upon payment. And again, I'm paraphrasing there. But let's take a look at some specific provisions related to payment issues within the right to know law that can prove useful. And probably the most important one is Section 701, where it says the agency is only required to provide the record in its current medium. Okay, what does that mean? Well, it's hard copy versus electronic. Okay, that's what we mean when we're talking about the medium that a record exists in. And we do not have to convert a record from one medium to another. I'll give you a quick example here. Building permits. Okay, our township's building permit process is all paper driven. Okay, the application materials, the processing materials that the codes enforcement officer uses, and then the approved building permit, all hard copy, kept in a file folder, kept in a file cabinet in the township office. So someone submits a right to know request and they want copies of approved building permits and they want them sent to them electronically because it's easy and it's free. But unfortunately, we don't have electronic copies. We only have hard copy. The agency is not obligated to scan in the hard copy records because that would be converting from one medium to another. So they do not have to scan in records in order to create electronic medium so that they can respond by email. They can if they want to, but then you cannot charge for electronic records. Okay, you can only charge for hard copy. If you have an electronic version, you must provide it if that's what the person is asking for. Now, like I said earlier, you cannot charge for electronic records. You can only charge hard copy. You want to check out our fee schedule, again, on the website, up to 25 cents a page, single-sided, black and white, 8.5 by 11, 8.5 by 14. Now, if a person asked to inspect records, okay, shifting gears here a little bit, under the right to know law, you can request copies or you can request to inspect the records, which is where you're coming into the office and actually looking at the originals or copies of the originals. Okay, the agency's in the driver's seat. They decide when within normal business hours it's convenient for the person to come in. If the person pulls out a cell phone and takes a picture of the otherwise public record, they're allowed to do that. As a matter of fact, they can bring in their own scanner or their own copier as long as it's not disrupting office operations, and they can make their own copiers at no cost from the agency. Okay, the agency cannot charge for labor. Okay, you cannot charge for like a redaction fee in case you have to black something out, and you cannot charge for legal review. These are simply considered the costs of doing business, the cost of conducting government as it relates to the right to know law. You can only charge what would be called an actual cost or a pass-through cost. A good example of that might be postage. Someone submits a right to know request, you have to make hard copies, so you run a bunch off, you charge 25 cents a page, you're coming up with your invoice, they want them mailed to them, So you put them all on your postage meter. The postage meter says this is going to cost $3.15 to mail these out. Well, you can add that $3.15 onto the invoice because it is an actual documented cost. You're allowed to do that. Another sip of coffee here. Excuse me. More payment issues? Well, kind of like I've been saying, no surprises. You get a right to know request, you do a quick estimate. We think it's going to cost about $30. Contact the requester before you actually start doing all the copying work on it, because they may be surprised. You'd be amazed at the number of people, both with agencies and the public, who think the right to know law is free. It's not. There are costs associated with it. So let people know what they can expect. A legitimate requester is willing to pay a nominal fee to get the public records that they need. Someone who is, abusing the law usually is not willing to pay to be a pain in the neck. All right, so reach out first and make sure everybody's on the same page and they're okay with paying that $30. And, I'm just pulling that figure out of the air. Okay, communication is good. If there's any confusion or ambiguity about a request, it's okay to talk to each other. All right. Now, like I said earlier, the law says ideally a mutual exchange, but push comes to shove, payment is due first. Then they get the records. Okay. And the right to know law doesn't speak to any sort of invoicing system. So what you set up is usually going to be okay. You can wait until you receive payment and the check has cleared before you provide the actual records. Remember, right to know law speaks about the responses, not providing the records. However, if you receive a right to know request and it looks like the response, the cost of the response is going to exceed $100, at that point, you can ask for payment up front before you begin processing the request. I kind of like to refer to this as a security deposit. The right to know law has this provision in it to ensure that agencies don't get stiffed for creating, all the work and paper for a big request, and then the person balks at the payment, because now you have a security deposit in place before you begin committing the time and resources to generate this big response. Then there's a thing called record discard. That hasn't happened in years. It hasn't really come up, so I'm not going to get into the details. But basically what it says is that what you need to take from this is that if a person submits a right to know request and they balk at payment and they owe your agency money for a previous right to know request, that kind of puts everything on hold, so that if you receive a subsequent right to know request, you can deny it based on the previous non-payment issue. So if a person owes you money, you can deny any subsequent request. But here's the thing, you want to make sure all of your paperwork is in order for the basis of denying that request, because it is a denial and it can be appealed. And when it is appealed, the appeals officer is going to be looking at all of your paperwork, your communication back and forth with the requester, how you calculated the fees that were owed and so forth, in order to determine, okay, have you met your legal burden? If everything's in order, the chances are good that the appeals officer will agree with you. If things look a little sketchy or incomplete or sloppy, maybe not so much, okay? You need to be careful about that, okay? But you can deny a right to know request if there are outstanding fees, and there's no statute of limitations on this. They don't go away after a month, they don't go away after a year, they don't go away after 10 years, okay? So keep that all in mind. Okay, let's say we didn't make it through the obstacle course and we are denying the request. Okay, well, remember what I said about meeting your legal burden? Here's where it becomes important, because you have to generate a denial letter. Okay, in that denial letter, we recommend a certain format. First, have a description of what was requested. Okay, now you may think, well, that seems rather obvious, but in some cases, Maybe the request wasn't written as clearly as you would have liked, so put it in your own words. We believe this is what you were asking for. Then you need to say why you believe these are not public records. This is where the rubber hits the road. Remember when I said about meeting your legal burden for withholding access? This is where you make your case. Maybe you're referring to one of those exemptions within the right to know law. This record, if we were to release it, just an example here, it would create, potential physical harm for this employee or this individual. And therefore, we are applying Section 708(1) of the Right to Know law, okay? Or, whatever appropriate section would be applicable here. All right, and then you put the name, title, or the name, title, signature, and contact information for the arrow. Because remember what I said, the arrow is the person legally responsible for responding to the right to know request. Then you put the date of the response, and this is important because a new deadline kicks in based on the date of the response, and then the procedure that the individual would follow for filing an appeal. And usually, in the majority of cases, they would file their appeal with the Pennsylvania Office of Open Records. Put down our website address as the contact point, and that way they can actually go to our website to find out specifically how to file an appeal, and they can actually file the appeal online using the interface with our website. Okay, so that's probably the best way to do it. And they have 15 of our business days to file that. So let's close here by quickly talking about appeals. When you deny a right to know request, the person has 15 business days, Office of Open Records business days, to file the appeal. Okay, and that would come usually through our website. When an appeal is filed, there are 4 elements that we look for. Okay, we need a copy of the original request, a copy of the agency response, provided there is one. Then the person needs to provide a statement as to why they think the records are public. And finally, why they think the agency's basis for denying the request is inappropriate. If any of these 4 elements are missing, the first thing we do is issue a deficiency order, and we give the person like 2 days, correct the deficiency. But if everything is there, then we proceed with docketing the appeal. Docketing means that it gets assigned a number. It's AP 2023, or I'm sorry, 2022, and then a 4-digit code. It gets assigned to an appeals officer, and we send out a notice of appeal to all the parties. But it's primarily for the benefit of the agency. It lets you know that we have an active appeal. Now, if you are an agency employee, or let's say you're an Arrow participating here today, and you receive a notice of appeal, best piece of advice I'm going to give you today, most important takeaway, is run, do not walk to your solicitor. Everything I've described up till now is an administrative process. Once an appeal is filed, it is a legal process. Okay, the Supreme Court of Pennsylvania has identified the Office of Open Records as an independent quasi-judicial tribunal. Yeah, that's a mouthful, but for our purposes here today, we are a court. And the higher level courts hold us accountable to adhere to these deadlines. Therefore, we must demand that you do the same. The Arrow is not expected to respond to appeals because there are certain forms that need to be used, there's certain format, language, et cetera. Your solicitor is. Okay, they're expected to know how to respond. You're still the boots on the ground, but do not allow them through a fault of a procedural error to miss a deadline. Okay, so run, do not walk to your solicitor. Say, hey, we got this from the Office of Open Records. It looks important. You might want to start working on it right away. Okay, and then they will know what to do. Now, the product of an appeal is what's called a final determination. This is the decision that comes from the Office of Open Records. It looks just like you would see coming out of your courts, your court rulings. Okay, they are legally binding. They're usually issued within 30 days, or if we ask for an extension and it's granted, then it might be longer. And they are available for review. If you have access to one of the legal services like Lexis or Westlaw, they're out there. You can find all of the previous final determinations, again, on our website in a searchable database. It's like in excess of 30,000 and counting. You can search on your municipality. You can search on a legal issue. You can put in a random text string and see if we have any final determinations that pop up. Okay, but they are out there. They are legally binding. There is the option of mediation that you want to take a look at. If when the person files the appeal, we ask them, would you be interested in mediation? And then when we send out the appeal notices, there's a form in there that describes it. And if everyone is agreeable to mediation and it looks like a good case, we take it out of the adversarial process. And sometimes it's simply a matter of a conference call, getting everybody talking to each other. And usually we can work out an agreement, I'd say in a little over half the cases. All right, but mediation is a tool that's available out there. You might want to take a look at it if you're dealing with an appeal to see whether that's the way you want to go. Now, our decisions can be appealed. Local agencies, you would have 30 days to go to your county court of common pleas and file the appeal. Same way with requesters. If they're not happy with our decision, they can continue on. State agencies, you can go to the Pennsylvania Commonwealth Court. When you do that, though, you have to notify us so that we can monitor the case and take whatever action we deem appropriate. The Office of Open Records is not a party to the appeal. We're simply a lower level decision maker. We're that lower level court. The dispute is still between the agency and the requester, and you would proceed accordingly, okay? But you can appeal our decisions to these higher level courts. Okay, so we're at the end of the presentation. If you have any more questions, now's the time to get them in. If after the presentation some questions come up, please feel free to reach out to our office. While we're kind of waiting to see if anybody has questions in though, I want to encourage you, take a look at our website. You've heard me say this before. It is the best government website you'll ever encounter. It is updated 6 days a week with new decisions, new information about the right to know law or the Pennsylvania Sunshine Act. Court cases, anything about government transparency in general usually makes it on its way to our website. There are guidebooks, for instance, the Arrow guidebook, 78 pages you can download for free. Lots of templates in there, sample language you can use, et cetera, et cetera. Guides for citizens, guides for law enforcement, et cetera, et cetera. A court case digest you can refer to, a training page. You know, and if you're a real geek about government transparency, you can subscribe to our Twitter feed, where every morning at 7 o'clock we will wake you up with all the information of the day related to government transparency, decisions we released, et cetera, et cetera. Question has come up here. You mentioned earlier about location where one could learn more about vexatious requester. Can you just repeat where that was? Okay. Actually, the vexatious requester language, two things you want to pay attention to. We do a webinar on the payment side of the right to know law. Look at our training calendar and you'll see when that webinar is next scheduled. It's typically on a Wednesday morning at 10 o'clock. Also, within the legislature, there are some committees. I think it's the local government committee for both the House and the Senate are looking at potential amendments to the right to know law that deal with what's called a vexatious requester. You can usually get on their websites, look at this proposed legislation, and you'll get an idea of what the legislature has in the hopper as potential amendments to the right to know law that would include this vexatious requester language. Okay, and that'll help you out. If you have further questions, you can reach out to the office and there might be someone who can steer you in the right direction there. Okay, but take a look at our website, and if you have any other questions, let's get them in right now before we sign off. Going once, going twice. Okay, folks, I want to thank you for your participation today. A lot of good questions, and we hope to see you at the next one, okay? We're signing off now. Take care.